Get ready for the dictation in 3, 2, 1, start. On the other hand, the respondent filed a counter affidavit stating therein that in a writ petition filed by one Ashwin Kumar, this court has directed that the respondent may inquire into the matter regarding the employees who have obtained the appointment under the dying in harness rules on the ground that their father or mother were in service of the respondent and died in harness, and on that basis some inquiry was conducted and it was found that the birth certificate submitted by the petitioner appears to be forged. Further allegation has been made that after inquiry it was found that only to get an appointment in the police department, the forged certificate of birth has been submitted by the petitioner. Therefore, the appointment selection of the petitioner is hereby cancelled. I have considered the submissions made on behalf of the parties and perused the record. From the averments made by the parties in the writ petition as well as in the counter affidavit, it does not transpire that petitioner was ever given a notice and opportunity before passing the order impugned. Admittedly, the petitioner's appointment was of 1989. In case some enquiry as submitted by the respondent was made and a conclusion was arrived upon that petitioner only to get an appointment has filed a forged certificate claiming that his date of birth is 15/11/1969, petitioner's case is that he has passed the high school in the year 1983 and certificate issued by the board was submitted mentioning therein that the date of birth of the petitioner is 15th November 1969. The respondents have not disclosed the fact that from where they have inquired into the matter and what are the documents to show thereunder that the certificate submitted by the petitioner was fraud. Therefore, in my opinion, it was incumbent on the part of the respondents to have a proceeding against the petitioner as provided under the rules. The regulations itself provides that in case of some misconduct or if on the basis of some inquiry it has been found that a person has obtained the appointment by playing fraud in the circumstance unless and until the procedure of inquiry as provided under the rules is followed, no disciplinary action can be taken against an employee. It is also not the case of the respondent that after verification from the petitioner also it was established that the appointment has been obtained by playing fraud. Therefore, in view of settled principle of law, it was not necessary to give a notice and opportunity and to have a disciplinary proceedings against the petitioner, as it is settled in law that fraud vitiates everything. Unless and until it is established, the procedure as provided cannot be bypassed. Article 311(2) of the Constitution of India provides for dispensation of inquiry in case a finding is recorded by the disciplinary authority that it is not possible and feasible to have an inquiry in the circumstances of the case. The court has taken a view in the similar fact and circumstances that in case at the time of appointment a caste certificate has been filed and subsequently it was found that the petitioner does not belong to said caste, in that circumstances without holding a full-fledged inquiry, the appointment selection of a person cannot be cancelled. In view of the matter, the alleged act or conduct of the petitioner was of at the time of his appointment while entering into service, therefore, the same would not constitute misconduct during the service, as such order of dismissal for alleged misconduct could not be passed against him. In my opinion, the submission made by the learned counsel for the petitioner have got substance and deserves to be accepted. I am of the considered view that the alleged conduct of the petitioner while entering into service cannot be alleged to be misconduct during service. In service law jurisprudence, both these stages are quite distinct and distinguishable, therefore, they should not be intermixed, otherwise, it will cause serious repercussion in the service law jurisprudence. Stop. Thank you.